Welcome everybody, and welcome to this Garden Court seminar on ECHR 70, Does the ECHR Protect Vulnerable Minorities? With a particular focus on Gypsies, Roma and travellers. This is the 70th anniversary of the signing of the European Convention on Human Rights, which was on the 4th of November 1950 at Rome. And this event is in commemoration of that. I'm David Watkinson, and I'm going to be chairing this session. Just a little about myself. I'm a founder member and former head of Garden Court Chambers. I was a practicing barrister for 40 years up until the end of 2012. My practice was mainly in housing and planning, and the planning was mainly on behalf of gypsies, travellers, and those with alternative lifestyles. Now that's enough about me. I've got a little bit of housekeeping to do. First of all, you have been placed on mute and you will remain on mute. You will see at the bottom of your screen that there is a question and answer facility. Please use that to put on your questions for the end of this session. You'll also see a chat facility. You can use that as well, but please don't use it for putting your questions. We will be circulating the recording of the session after the meeting, and also circulating the slides which you'll be seeing. As I've already indicated, this webinar is being recorded. So that means that the audio and video of the panelists and anyone who speaks, if they are unmuted, will be recorded. And this webinar may be shared on our marketing channels, including our website and social media. There are instructions on the chat function if you are experiencing any technical difficulties. So please refer to those. Now I'm going to say a few words of introduction about the panelists. Although these are two whose impact on Gypsy and traveller law is such that they hardly need any introduction. Marc Willers, Queen's Counsel, and Tessa Buchanan have between them a total of 40 years of legal practice. Though it'd be only fair to say that Marc has the majority of those. Their practice has been in the fields, or is in the fields of planning, housing, social welfare, and discrimination. And they've appeared in a string of leading cases. Most recently, they joined forces in the case of London Borough of Bromley and others against persons unknown, in which they successfully challenged the use of borough-wide injunctions against gypsies by local authorities. I think you'll be hearing more about that later on. And they also have a case in hand concerning the legal definition of a gypsy. And again, I think you'll be hearing more about that. They are also co-authors of Gypsy and Traveller Law. Again, you'll be hearing more about that. Published by the Legal Action Group at the beginning of this year, the 3rd edition. So it is as bang up to date as any legal work can be. I also am a contributor to that book. I just thought I'd throw that in. However, Marc and Tessa are not content with legal practice and authorship. Marc is a trustee of Friends, Families and Travellers, and Tessa of the London Gypsies and Travellers organisation. These are not formal posts. They mean work, serious work. So how we're going to run this is that you'll be presented with a series of slides and Marc and Tessa will take it in turns to speak to them. That'll last for about an hour, and then we'll have 15 or 20 minutes of answering questions. Then, at the very end, I have been asked to prepare a poem in commemoration of the European Convention. I'll tell you more about that at the time. But now it's over to Tessa and Marc.
Thank you very much, David, for that introduction. And it's a real privilege for us to be here this afternoon talking to quite a large number of delegates. Over 300, I think, signed up for the seminar or the discussion. So I hope we provide you with some useful information and you learn a bit more about how the ECHR has protected Gypsies and travellers and Roma over the years. Perhaps it's worth beginning with who we're talking about, Gypsies, Roma and travellers. The communities or groups that the talk will cover include indigenous Romani Gypsies who have lived in the United Kingdom for many hundreds of years. The first reports of Romani people on these shores date back to the early 1500s. Irish travellers who are a separate ethnic group and have been documented as living and travelling around the UK for many hundreds of years too. Roma, who I would ascribe as those who have predominantly lived in mainland Europe, but have supplemented the indigenous Romani Gypsy population in various waves. Most recently, in recent years, as Roma have travelled to this country for work and to avoid persecution, predominantly in Eastern Europe. The indigenous Romani Gypsies that live in Wales often refer to themselves as Welsh Gypsy travellers or Cale. And then in Scotland, we have Scottish Gypsy travellers who again predominantly arrived in this country and at about the same time as in fact, were part of the first wave of Romani people, but have lived in Scotland for many hundreds of years. New travellers are those that have in the past been known as New Age travellers. First, second generation people who have decided that living an alternative lifestyle on the road is for them. And they often travel around working at fairs and cultural events and ascribe to an alternative lifestyle which really is not being properly addressed. They don't have sufficient sites to accommodate themselves, just like Romani Gypsies and Irish travellers. Then we have travelling show people, some of whom are from Romani Gypsy and Irish traveller families, but many are not. And they too have their own separate accommodation needs and travel around as they have done historically to fairs and circuses and other showgrounds to carry out their work. We haven't put down on the list boat dwellers, but we also represent, and indeed a lot of what we're going to say relates to those that live in boats on the canals and rivers up and down the country. They too have many of the same difficulties that other Gypsies, Roma and travellers have. But in terms of numbers, if you put all the various groups together, we could be talking in excess of 500,000 people in the UK. Certainly the estimates for Gypsies and travellers from the Commission for Racial Equality and the Equality and Human Rights Commission exceed 300,000. And then if you add in Roma people who've come to this country in recent years, while we're well above 500,000. Just dealing very briefly with the history of these groups, and indeed their treatment by the rest of society here and in Europe. It's really a litany of prejudice and discrimination, persecution through the ages. When Romani people first arrived in this country, they were described as Egyptians, and it's from that word that we get the term gypsy. And in 1505, Henry VIII issued a proclamation which effectively banished Egyptians or gypsies from these shores. Then in the 1530s, Queen Mary, his daughter, issued another proclamation, the Egyptians Act, in fact, it was a statute. And that ordered that gypsies and those that fell into company with them be sentenced to death. And so, pretty stark persecution way back 500 years ago in the UK when gypsies first arrived on these shores. And unfortunately, the persecution has continued in this country and perhaps more obviously in mainland Europe ever since. Not to the same degree, although you may be aware that in the Netherlands there were gypsy hunts, would you believe? And in Romania, gypsies or Roma were enslaved. We know much more recently, in the 20th century, that the Roma population in Europe suffered terribly at the hands of the Nazis in what was known as the devouring or the Porojmus, where estimates of 500,000 to more than 1 million Roma died at the hands of the Nazis in death camps and elsewhere. So these are pretty grim accounts of the ways in which gypsies, Roma and travellers have been persecuted through the centuries. And one has to wonder how during World War II the Nazis got away with it, but it's all down to propaganda. And unfortunately, that propaganda persists. We don't have the well-oiled Nazi propaganda machine spreading racist hate speech and vilifying and dehumanizing gypsies, Roma and travellers. But we have hate speech online, we have hate speech in the media, and we have hate speech uttered by our politicians who you'd think really ought to be above that kind of abuse. And unfortunately, that does dehumanize gypsies, Roma and traveller in the eyes of the general population. And that leads to discrimination, and it's widespread. And we're going to be saying a little bit more about that and the impacts of that discrimination on the people we're talking about. But it all emanates from the historical persecution of these groups over the centuries. I'll leave it at that, and perhaps we'll turn on to the next slide.
Thanks so much, Marc, for that really interesting introduction. And before we move on to the convention itself, I'm just going to ask you to tell us a little bit about this photo, which may well be familiar to some of our listeners. Marc, I understand it's Eli Frankham.
It is. Eli was a very well-known campaigner for Romani rights. He set up the National Romani Rights Action Group, as far as I can recollect. And he was also a boxer and a poet. And he ended up being one of my clients because in, I think it was the early 2000s, there was a fair in Kent known as Horsemonden Fair, which had been in existence for many hundreds of years, that the local police force and the Secretary of State decided should be closed down or prohibited. The powers to do so were emanated from the Public Order Act, and the Secretary of State decided to issue an order banning the fair, and Eli Frankham challenged that decision by way of judicial review. And I remember that he also protested at the closure, taking a Romani Gypsy wagon or Vardo down into Horsemondon, where he was stopped from proceeding by the police. And there was a lovely photo of him sitting on the wagon with Jake Bowers, I think, who's a well-known Romani Gypsy journalist by his side. We lost in that challenge, unfortunately. We took the case further to the European Court, but got nowhere. I mean, our simple argument was that there was really no need to ban the horse fair when we seem to be quite happily able to accommodate much larger fairs and events such as the Notting Hill Carnival, with adequate policing. The banning of the fair itself was really something which would have a significant impact on the traditional fair culture of gypsies and travellers.
Thank you very much. So Marc set out the background to the minority group we're talking about, Gypsies, Roma and Travellers, and I'm just going to do the same in relation to the convention itself, known as the European Convention on Human Rights, although its full name is the Convention for the Protection of Human Rights and Fundamental Freedoms. As we've heard, it arose in the context of the post-World War II era, and the rise of communism came into force in 1953. And one thing which I think it's important to remember about the convention is that there was a strong British presence in drafting it and bringing it into force. Sir David Maxwell Fyfe, who was a Conservative MP, was very instrumental in drafting it. And the UK, which ratified it in 1951, was one of the first countries to do so. And it was also one of the first countries to allow individual complaints to go to the European Court of Human Rights. So this is not something which has been foisted on us. This is something which we have helped create and which we should be very proud of in that sense. So it's enshrined now in domestic law, the Human Rights Act 1998. Before that, people could rely directly on the rights that it bequeathed to them, but only by bringing a case themselves to the European Court of Human Rights, which was a difficult and time-consuming process, although, as we've heard, Marc and I think David have both done that themselves a number of times, but it's certainly not quite as simple as relying on your human rights in front of the local district judge, which we can now do with the Human Rights Act 1998. And that operates by way of making it unlawful for a public authority to act in a way which is incompatible with a convention right. And that includes courts and tribunals, which must also not act incompatibly with convention rights. In addition to that, so far as it's possible to do so, legislation should be read and should be given effect in a way which is compatible with convention rights. And if it's impossible to do that, if the court is satisfied that the legislation is incompatible with convention rights, then it may make a declaration of incompatibility. The Human Rights Act didn't incorporate every single right contained in the European Convention, but it incorporated the main ones, and certainly all the ones that we've featured on this slide. In the sort of publicity and the blurb for the presentation, we referred to the trope or the idea that the treatment of vulnerable minorities is a barometer of a society's respect for human rights, and we'll be looking at what the treatment of Gypsies, Roma and Travellers tells us about the UK's compliance with the Convention. But I think it's also important to think about it the other way around and to ask what a society's and what the UK's understanding of and treatment of human rights tells us about the treatment of minorities, because the more disdainful a society is about human rights, the more I think you should be worrying about the position of minorities. Some people may remember the speech given by Theresa May at the Conservative Party conference about 10 years ago. I think it was maybe 2011 when she was Home Secretary. And it was the fairly notorious one where she said that the Human Rights Act had prevented an illegal immigrant from being deported because of his pet cat, which was quite swiftly rebutted as being not an accurate portrayal of the situation. But obviously the point there, and unfortunately it was reasonably effective, was to ridicule human rights. And unfortunately, in many ways, things have not got better since then. Having said that, there is a great deal to celebrate and a great deal to continue to fight for. And those are the sort of substantive rights themselves. So we've set out on the slide the ones which we consider to be of most relevance to Gypsies, Roma and travellers facing infringements on their way of life and other forms of discrimination. Firstly, we've included Article 2, which is the right to life. That states everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. So the death penalty, which obviously we don't have. It is qualified, so that right won't be contravened if it results from a use of force which is no more than absolutely necessary in pursuit of one of the specified aims, such as effecting a lawful arrest. And it's thankfully not perhaps the most relevant of the rights that we'll be talking about today, which is a good thing. But it can arise if, for example, somebody were to be killed during whilst they're in custody or during an unlawful arrest, then it could be relevant in that situation. Then we move on to Article 3, which provides that no one shall be subject to torture or to inhuman or degrading treatment or punishment. This is an unqualified right, so there are no situations in which it's permissible to subject someone to torture under the Human Rights Act. This could be, for example, ill treatment in custody. There are also some cases on sterilisation, forced sterilisation. But it is also theoretically possible, at least for somebody who has been refused state support and is completely destitute, that they would be in such a condition, in such suffering, that their rights under Article 3 would be breached. And we know that from the case of Limbrella and the Secretary of State for the Home Department, which was a House of Lords case of about 15 years ago. Now, this isn't on the slide, but I put it in because I think it could be relevant. The prohibition of slavery and forced labour, which states that no one shall be held in slavery or servitude or shall be required to perform forced or compulsory labour. And that's relevant perhaps in the context of modern slavery. It may be that somebody's been trafficked into the country and held in conditions amounting to slavery, in which case their rights under Article 4 would be in play. Article 6 is the right to a fair trial. This provides that in the determination of a person's civil rights and obligations or of any criminal charge, they are entitled to a fair and public hearing, first of all. That should take place within a reasonable time. It should be before an independent and impartial tribunal established by law, and judgment should be pronounced publicly, although the press and the public may in some circumstances be excluded. And this has often been relied upon where people have been evicted without due process or without being able to contest the allegations. But it is also potentially relevant to somebody who can't get legal aid. It would be going too far to say that Article 6 guarantees a right to legal aid, but there is the case of Airy, which states that if the assistance of a lawyer is indispensable for effective access to the court, then that may be the result that legal aid has to be provided. Article 8, probably the most common, probably the most famous of all the rights contained in the Human Rights Act and the Convention. And this provides that everyone has a right to respect for his private and family life, his home and his correspondence. And there should be no interference by a public authority with those matters, with the exercise of that right, except such as is in accordance with the law and as is necessary in a democratic society in the interests of the prescribed aims, which are national security, public safety, the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, and for the protection of the rights and freedoms of others. And this is relied on in numerous different ways, which you'll see throughout the course of this seminar. So to prevent eviction, as a defence to an injunction, in support of a planning application, challenging suitability of accommodation, and also in relation to non-accommodation issues. So there are some cases dealing with the removal of children into state care, or with verbal abuse and threats. Article 11 is the right to freedom of assembly and association. That's another right which is qualified, so it can be restricted in circumstances. It's often a right which we see coming up in protest cases, which aren't obviously directly relevant, but do share a lot in common with many of the cases establishing Gypsy and traveller rights. And we might see that when we come to the question of wide injunctions. So in the case Marc has just been talking about, the horse fair, perhaps he'll tell us, but it could be that Article 11 was, or potentially a relevant right. He's nodding. And then Article 14, the prohibition of discrimination, that's another important one. And this is that the enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination on any ground. And then they list a number of grounds, including sex, race, colour, language, religion, political or other opinion, but also other status, which is something that has been generally interpreted fairly widely. But of course, probably the most relevant one for our purposes is that of race, and the ethnicity of Gypsy, Roma and traveller all constitute races for this purpose. This isn't a standalone right, so it doesn't give anything to anybody purely on its own, but it means that if another right is being infringed in a way, or is being impacted upon in a way which is discriminatory, then that may be a breach of Article 14 together with that right. So the question is, firstly, do the facts of the case, does whatever's happened fall within the ambit of one of the other convention rights, such as Article 8? And then, has the person been treated less favourably than somebody else in a similar situation? Is the reason for that less favourable treatment one of the protected grounds, such as race or another status? And then, is that difference justified? Is it a proportionate means of achieving a legitimate aim? And if not, then there's likely to be an infringement of Article 14 plus the other right. And then finally, Article 2 of the first protocol. This is the right to education. It states that no person shall be denied the right to education, and the state shall respect the right of parents to ensure such education and teaching in conformity with their own religious and philosophical convictions. We'll come to that in a little bit more detail later, but it's relevant given what is unfortunately a very well-established educational disadvantage in relation to Gypsies, Roma and traveller children. Marc, is there anything that you wanted to add in respect of those?
Thank you very much, Tessa. That's a really comprehensive review of the convention rights. Articles 2 and 3 predominantly play out in cases involving Roma in Europe, and cases where there have been unexplained deaths in custody or murders by far-right killers of Roma. For example, we have the case of Anguilova, where Judge Bonello asked the question in the minority judgment: why is it that Roma again and again are killed, but the court itself doesn't seem to be persuaded that race has anything to do with it? And you can see there the interplay between the killing of an individual, unexplained, as it was in that case in a death in custody, and the linkage between that killing and the ethnicity of the individual, and his frustration that it wasn't being picked up and addressed by the court. And that played out in a case called Nachova against Bulgaria, where the court concluded that actually the killing of Roma by military police was racially motivated. So we have those kind of cases arising and continually so in mainland Europe and addressed under Articles 2 and 3. Your point about Article 6 is really important in terms of the ability to pray it in aid when arguing for public funding or legal aid in order to be represented, because access to justice is so important. In this country, we tend to be working with cases involving breaches of Article 8 of the Convention. And that is not just a right to respect private and family life, but has also been held to be a right for respect for one's traditional way of life. And we'll talk a bit more about that and how it plays out in Gypsy and Traveller cases later. Article 11, yes, that did come into play in the Frankham case. And Article 14 is an article which is relied upon in any case where the breach of another right enjoyed by the Convention is perhaps involves some form of discrimination. As far as the right to education is concerned, there have been a number of cases in the European Court of Human Rights brought by, amongst others, the European Roma Rights Centre, and as a declaration of interest, I'm on their board too. But so I would perhaps say something about those cases, but they've been at the forefront of many of the Strasbourg decisions on Roma rights over the years, and most recently have been fighting against segregation in education. For example, the case of Sampanis and Ursus, where segregation continues unabated, it seems, in many member states in Europe, and also in cases where one finds that the Roma children are the ones who are predominantly populating special schools for no good reason. And that was borne out in a case called DH against the Czech Republic. But the problem with some of these cases, when they go to Strasbourg and they're ultimately successful, is that then there's a lack of implementation. And so these discriminatory practices continue again and again. So we do find, I think, perhaps in answer to the question posed at the very beginning of your slide show, which I'm grateful for Tessa having created, the answer to the question as to the protection of rights and whether or not the European Convention does its job. Well, it does, but then states have to implement judgments of the court and respect the rights protected in the Convention at the domestic and ground level. And that, I'm afraid, isn't happening. Thank you.
Thanks very much. Before we move on, I just want to touch upon a few other conventions which are much less, well, some of them are much less well known than the European Convention on Human Rights, but which are still really important. Firstly, the United Nations Convention on the Rights of the Child. As is obvious, this comes from the UN rather than Europe, and it's been signed and ratified by the UK. People may be familiar with it because it's the source of the obligation to treat the best interests of children as a primary consideration in any relevant decision. That comes from Article 3 of the UNCRC, and it's been enshrined in domestic law by Section 11 of the Children Act 2004, which requires various public authorities, including local authorities, to make arrangements for ensuring that their functions are discharged, having regard to the need to safeguard and promote the welfare of children. And that any services provided by another person pursuant to arrangements they've made are also provided, having regard to that. And we know, because the Supreme Court said so in the case of the famous case of ZH Tanzania, that Section 11 has sort of incorporated the spirit of Article 3 and is what requires public bodies in their decision making to treat the best interests of the child as a primary consideration. This is obviously something which has been argued about a lot in the courts, and one of the most important cases dealing with it is another Supreme Court case, Zumbas and the Secretary of State for the Home Department from 2013, which clarified that the best interests of the child are integral to any proportionality assessment under Article 8. So in deciding if something is a proportional interference with Article 8, the best interests of the children are really important to that. That they are a primary consideration, but not always the only primary consideration, and they're not in themselves the paramount consideration. The best interest of the child can be outweighed by the cumulative impact of other considerations, but no single other consideration should be treated as inherently more significant. It's important to ask the right questions in a methodical way to make sure that you do properly take into account the best interests of the child. And perhaps obviously it's important to know the circumstances of the child and to understand what their best interests are before asking whether those are outweighed by something else. This is a really important right, and I think Marc might sort of talk to us briefly later about his case of Stevens and the Secretary of State for Communities and Local Government, where we saw that playing out in a planning context. And then we have the European Social Charter. This should really be as important as the European Convention on Human Rights. It's the kind of social and economic sister charter, it's sometimes described, to the civil and political rights protected by the Convention, but it's unfortunately much less well known and really much less helpful in some ways, because it can't be, it's not directly applicable. There is a procedure whereby NGOs and trade unions can make a collective complaint that the rights are not being observed by a state, but the UK hasn't signed up to that. So it's something which is less, it's important, but it's less directly relevant in sort of day-to-day life of litigation. And then finally, the European Framework Convention for the Protection of National Minorities. This is again has been signed and ratified by the UK, and in doing so, it agreed to guarantee to national minorities the right of equality before the law, and to adopt, where necessary, measures to promote their full and effective equality, and to promote conditions for the conditions necessary for national minorities to maintain and develop their culture. Whether we see that in the way that the traditional way of life of Gypsies and Travellers is promoted or not promoted, I think is very much open to question. One important thing of the Framework Convention is that it says that you mustn't promote policies designed to assimilate minorities against their will. And again, the lack of suitable sites, which we'll come on to, and the pressure on the traditional way of life of Gypsies and Travellers really does sit very uneasily with that particular obligation. Marc is going to talk to us now about site provision and planning. Marc, is there anything you want to say on this topic before moving on?
Well, only to perhaps echo your point about the European Social Charter, which was revised, by the way, in 1996. And the ERRC, the European Roma Rights Centre, have regularly brought cases, collective complaints before the European Committee of Social Rights that polices the Charter. One case that comes to mind is the ERRC against Ireland, where the committee concluded that there was a breach of one of the provisions of the European Social Charter in circumstances where they found that there was insufficient accommodation for travellers in Ireland. But as you say, we haven't signed up in the UK to the collective complaints procedure. So although the committee's decisions are perhaps of persuasive value, we can't use that collective complaints procedure ourselves, and nor can our clients. As far as the convention is concerned, the Framework Convention, that was first, I think, given a first airing in the Chapman case, which I'm going to talk about. And I think it is going to be more important as time goes on, and indeed it may feature in another case that we're going to talk about regarding the definition of what it means to be a gypsy or traveller in planning. Yeah, nothing else I wanted to add on those points. Thanks.
Thanks very much. So site provision.
Well, I'm going to speed through this next slide, if you will have it. We're talking under the heading site provision about planned site provision. Gypsies and travellers that wish to live in their caravans need to apply for planning permission in order to do so. There is a difficulty there because, for a start, given the prejudice that they tend to encounter up and down the country, there is a marked degree of NIMBYism that they will often face. In fact, ordinarily face, and objections come thick and fast from the local community whenever there is an application made for a gypsy or traveller site to be developed in the area. And on top of that, it's problematic anyway because unlike many other types of development, there is very little in development plan documents produced by local authorities to assist gypsies and travellers to find suitable sites that they could possibly hope to get planning permission on to develop. And that lacuna or lack of planning policy to address their needs and identify sites where they might move to and develop has been historical. It dates back to the 1960s. It was in 1960, indeed, that the government of the day passed the Caravan Sites and Control of Development Act. And that act closed the commons where gypsies and travellers had historically resorted to and camped and used both as winter quarters and summer sites. And it closed those commons to them so that they then found it more and more difficult to find anywhere to stop. And for a number of years, the difficulties continued. In 1968, the government of the day passed the Caravan Sites Act, which included a duty on local authorities to provide sites, a suitable number of sites for gypsies and travellers in their areas, resorting to those areas. And that act and that duty led to the establishment, the creation, the construction of about 300 sites up and down the country, local authority sites, many of which still exist. But unfortunately, many local authorities didn't comply with the duty. And so there were still insufficient sites by the time that a Conservative government in 1994 decided to repeal that duty and instead promote private site provision and do that through planning policy. That was a very retrograde step, I'm afraid, as far as those that represent gypsies and travellers are concerned and the campaigning organisations that support them. What we think should have happened is that the government should have cracked the whip and made sure that local authorities complied with their obligations and continued to make proper site provision. But instead, the policy of the government of the day, the Conservative government of the day, was privatisation, and so the idea was, and it really was pie in the sky, but the idea was that gypsies and travellers should be able to provide for themselves and encouraged to do so. But the fly in the ointment, or the difficulty with that idea, was that the policy that was then published by the government in something called Circular of 194 was just that, policy which local authorities could and did ignore. They didn't assess the needs of gypsies and travellers in their area, and they didn't identify land to meet any need that might be assessed. And it wasn't until 2006 that another government of a different colour came in and decided to shake things up. And Circular 1 of 2006 was much more positive. It required local authorities to carry out proper assessments, that they should be benchmarked by regional bodies, and then sites should be identified. And as a consequence, there were more sites identified and more permissions granted, albeit it was still a private provision. And the numbers of local authority sites have never really gone up since 1994. And many of those sites are very overcrowded. Then in 2012, Circular 1 of 2006 was repealed or withdrawn and replaced with a document called Planning Policy for Traveller Sites. That document was upgraded or revised in 2015. And when it was revised, the definition, the planning definition of what it means to be a gypsy or a traveller was also revised. Up until that point, Circular 1 of 2006 and the 2012 document had identified gypsies and travellers as being those not ethnic, not based on their ethnicity, but those who travelled for an economic purpose, or those who had ceased travelling temporarily or permanently on grounds of ill health or old age, or in order to educate their children. The 2015 policy, when it was introduced, had an amended definition within it, and that definition deleted or did not include the words "or permanently." Two little words, "or permanently." But what that change in the definition means is that those gypsies and travellers who are too old to travel, or too ill, or perhaps disabled and unable to travel as a consequence, will not fall within the planning definition of what it means to be a gypsy or traveller. They may still be ethnic gypsies and travellers, Romani gypsies, Irish travellers. They may have lived in caravans all their lives, perhaps been born in a caravan, want to die in a caravan. But unfortunately, because they don't fall within the definition in the 2015 policy, they will not be able to rely upon the positive elements of that policy, which promote site provision. They will be in very little, in no different a position, one might think, than you or I, or any of the settled population who go to the planning authority or on appeal to an inspector and ask for planning permission for a caravan site, because they simply won't be able to rely on the positive policy in the that has been created to address the shortage of sites by the government. And that, we say, and we will be arguing in a case that is coming before the court in December, on I think the 10th and 11th of December. And I say we, I mean myself and Tessa and our solicitors, Dayton Pierce Glynn. We'll be arguing on behalf of a Romani gypsy lady that is a discriminatory definition, which indirectly discriminates against the elderly and the disabled, and indeed women who are the predominant carers of elderly and disabled people within gypsy and traveller communities. And we're hopeful that the court will agree, and that there is really no justification for that definition change and the impact that it has on the most vulnerable members of the gypsy and traveller community. So that's an issue to watch out for. Gypsy status, which is effectively what I'm talking about here, the question of whether or not one can fall within a planning definition of what it means to be a gypsy or traveller, has been a hurdle that gypsies and travellers have had to overcome for many, many years. But it's much more difficult now, as I said, for the elderly and the disabled and those that care for them to obtain planning permission because of that definition change. What we see as those that represent gypsies and travellers at planning inquiries where they are appealing against the refusal of planning permission for caravan sites is not only that they're up against a lot of NIMBYism and perhaps objections which really have no basis, but also that they're caught between often a rock and a hard place, because without there being land identified by local authorities to meet their needs, they have to choose almost blind a piece of land that may do just that, without any guidance from the local authority, without any real measure of whether or not they'll be successful in their endeavours. And often in areas which are covered by Greenbelt, they have an additional burden of having to prove that there are very special circumstances as to why they should be granted planning permission. And that can make it extremely difficult, if not impossible, for some of them to find sites. And that's why we still have about 12% of those that live in caravans living on unauthorised encampments up and down the country, without a place to call their home, without a site from which they can travel in the summer months, without a site that they can overwinter, without a site from where they can ensure that their children access the education they need, and without having a site from which they can also access healthcare. And that has an obvious knock-on effect in terms of educational attainment and achievement, and their general health, morbidity, mortality, and so forth. The other thing I wanted to say is that that all plays out, or is part of the arguments that one would run on behalf of gypsies and travellers under Article 8, because when applying for planning permission, and indeed arguing on appeal, if, as is often the case, permission is refused by a local authority, the Article 8 rights engaged, the right to respect for one's home, one's family life, and one's traditional way of life are very much at the forefront of any appeal. And that includes the arguments about the best interests of the children. And the courts have accepted, as one would expect they would, that those with children who are seeking planning permission for a caravan site, those gypsies and travellers, are entitled to rely upon the best interests of their children, which are undoubtedly going to be met by them having a stable and secure site from which to access education and healthcare. That is a primary consideration, but it's not the primary consideration. And so the cases of ZH and Zumbus were relied upon in that regard in a case that I ran called Stevens, and Mr. Justice Hickinbottom accepted quite correctly that the best interests of the children were something that a decision maker at first instance or on appeal should take into account. And indeed, planning policy for traveller sites makes it clear that the best interests of children need to be taken into account when deciding whether or not to grant planning permission for a family with children. So those are elements that one will have to one will argue and will have to be taken into account by a decision maker. The other thing that the other perhaps important point that one takes from the case law on Article 8 of the Convention is that in the decision in Chapman against the United Kingdom, the European Court of Human Rights concluded that living in caravans was an integral part of the traditional way of gypsy life, and that demanded respect. And also that states had, given the vulnerable position of gypsies and travellers, states had have a positive obligation to facilitate their traditional way of life. And those are very important points in any gypsy or traveller case. And they led on to a decision of Mr. Justice Burton in a case called Clark against Tunbridge and Malling, I think it was, District Council. A decision by him where he considered the question of whether or not a decision maker, an inspector on appeal in this case, should have given weight to and taken into account an aversion to bricks and mortar on the part of my client, Mr. Clark. In the planning appeal, an inspector had concluded that Mr. Clark had an option. He didn't have to live on the land in his caravan with his wife. He could go to the local authority and move into bricks and mortar accommodation. But he did so without considering the strength of Mr. and Mrs. Clark's aversion to bricks and mortar, they being Romani gypsies who had always lived in caravans. And the High Court judge made the very obvious point, an analogy, which has perhaps been repeated on a number of occasions since then, that to require a gypsy or traveller with a strong cultural aversion to move into bricks and mortar would be like requiring him to move into a rat-infested barn. And he made that point, having regard to the decision in Chapman, the requirement that states have following that case, that they facilitate the traditional gypsy way of life, an integral part of which is living in caravans. So those are a couple of Article 8 cases which we rely on regularly in the planning field.
Tessa and Marc, you've got 5 to 10 minutes left. We're just on the hour, so bear that in mind.
Great, thank you very much, David. So the flip side of this serious shortage of sites is, as Marc alluded to at the end there, people being forced into accommodation which is not suitable for them, which is bricks and mortar, or alternatively applying to the council for assistance with accommodation. So I just want to touch on those issues now. Firstly, in relation to the suitability of accommodation, this often arises in the case of homeless applications. So people who don't have anywhere to go and who need assistance from the local housing authority. Now, I'm not going to set out the framework of the homelessness legislation because that would be a seminar in itself. But those of you who work in the area will know that the end goal for most people who apply as homeless is to have the main housing duty, as we call it, accepted towards them, which is when the local authority says, yes, we accept that you are homeless, you're eligible for assistance, you're in priority need, and you didn't become homeless intentionally, and therefore we accept that we have to secure accommodation for you. But the difficulty for many gypsies and travellers is that that is only halfway down the road, as it were, because then we get to the stage of trying to secure that they are provided with accommodation which is suitable for them. The really vivid quote which Marc gave from the Clark case in a planning context, which is that bricks and mortar, if they're unsuitable, would be just as unsuitable as an offer of a rat-infested barn. Unfortunately, has not really sort of had as much impact in the homelessness field as one might have liked. And there have been a series of cases, often in the Court of Appeal, where gypsies and travellers who've been offered bricks and mortar accommodation have challenged that on the basis of Article 8 or Article 8 and Article 14. There's the case of Price and Carmarthenshire, 2003, where it was held in the High Court that if an applicant had a cultural aversion to bricks and mortar, then the offer of conventional housing would be unsuitable. And in that case, the local housing authority was found to have given insufficient respect to her rights under Article 8. But there have been some cases since then which have not been as helpful to those who are fighting for Gypsy and traveller rights. The case of Cadona, which I think David may be responsible for, Cadona in Mid-Bedfordshire, where Article 8 and Article 14 were relied on. And the court said, if there aren't any sites available, then it's not a breach of the Human Rights Act to offer bricks and mortar unless it falls below the Wednesbury minimum standard of suitability. And then a few years later, the case of Sheridan and Basildon, which I think possibly was Marc's case, he'll correct me if I'm wrong. Anyway, in that case, the Court of Appeal said that the cultural aversion wasn't enough to make an offer of bricks and mortar Wednesbury unreasonable, even if it might risk bouts of depression. So Gypsies and travellers are in an incredibly frustrating position, really, because as Marc has described, there have been long-standing failures by local authorities to provide sufficient sites, leading to serious shortages of accommodation. But then, in effect, those shortages can be relied on to justify offers of bricks and mortar and to really force people into bricks and mortar who don't want to be there and for whom it's not their way of life. And there's just a really sort of a biased assumption, essentially, that whilst most local authorities wouldn't dream of offering a caravan to somebody who wasn't used to that way of life, they seem to think it's perfectly reasonable to offer bricks and mortar to somebody who has grown up and whose traditional way of life is living in a caravan. And it's really hard to see how this position squares with the prohibition on forced assimilation under the Framework Convention, because the effect is that we are forcing people from one way of life into another one. And we're in a position really where if you want to show that it's unsuitable, you're having to rely on quite serious sort of psychiatric evidence and forcing people to show mental harm in order just to have accommodation which is suitable for them. Suitability of accommodation is also an issue in respect of allocations, i.e. long-term offers of social housing. But in one sense, we're in a slightly stronger position because we're not talking about emergency accommodation where the local authority have to provide something that night. We're talking about somewhere where the applicant is expected to live possibly forever, in any event for many years. And so I think the arguments there as to what's suitable have to be stronger. But there's another issue which arises in respect of allocation, which is the requirement which many, many local housing authorities have within their allocation scheme for applicants to have a local connection. And this can be as much as 10 years residence in the borough before you can get any priority within the scheme or even qualify for the scheme. And that's been challenged in a number of cases by Gypsies and travellers who have pointed out that a requirement that you would be living in the borough for perhaps 10 years inevitably operates more harshly on people who live a nomadic way of life. And there has been some success in that regard. A recent Court of Appeal case, I think it was reported under the name of Gulu and Hillingdon, but there was a joined case of TW and Hillingdon where it was found by the Court of Appeal that it was potentially discriminatory to have this provision of a 10-year residence requirement. And then moving on to possession proceedings and eviction, I'm not going to set out a history of how we've come to the position we're in where we can rely on Article 8 as a defence to possession proceedings, because it would take half a seminar. But I think it's fair to say that we have been, by we, I mean really domestic courts, have been dragged to that position, kicking and screaming. It went back to the European courts a number of times before it was recognised that people who live in accommodation or on sites should be able to challenge the proportionality of their eviction before a domestic court, and that if they can't do that, then there is a potential breach of their Article 8 rights. And Gypsy and traveller cases were really important in achieving that. The case of Connors in the UK, and Doherty in Birmingham City Council, and also I think it's Buchanan in the UK, were all cases involving Gypsies and travellers where they helped establish this really important position, which is that Article 8 can be relied on as a defence to possession proceedings in the domestic courts, although at the moment it is in reality limited to cases brought by public authority or public body landlords. But it's an important point, I think, because firstly, in answer to the question which we posed at the beginning as to the UK's compliance with the convention, we can see that on occasions it's been reluctant. We can also see that Gypsies, Roma and travellers and the cases brought on their behalf are not just a barometer of compliance, but also a force for change in themselves. And I think also, and this is really a tribute to those like David and Marc and others who brought these cases repeatedly, is to keep going, because we do end up with achievements. I'm going to move on now with Marc to wide injunctions, which Marc will say something, I think, quite briefly about, as we're short on time. But
thanks, Tessa. Yeah, there's been a trend on the part of local authorities in recent years to make applications for wide or borough-wide injunctions, which effectively prevent Gypsies and travellers and others from setting up unauthorised encampments on land which they own within those boroughs, within their boundaries. And that trend came to a head in the last, certainly in the last 18 months, when it became the subject of a case brought by Bromley, the London Borough of Bromley, in the High Court, seeking one of these wide injunctions. And Tessa and I were instructed by London Gypsy Travellers and Community Law Partnership. Chris Johnson was the solicitor in the case. We were instructed to intervene on the part of London Gypsy Travellers to put the other side of the coin, the other side of the case, as it were, to the court, to ensure that the court understood its powers and exercised its discretion in an appropriate way. And we were grateful for being granted intervention status. And having made representations, the Deputy High Court Judge, Leanne Mulcahy QC, refused to grant the injunction in relation to the unauthorised encampments on the land. I think it was 170 parcels of land in Bromley. And she gave a very forceful and comprehensive judgment when doing so. Bromley appealed against that decision to the Court of Appeal. And one might think, having read the judgment, that was a bad idea, because the Court of Appeal resoundingly upheld the judgment of the Deputy High Court Judge, and indeed went further than the High Court Judge had done, giving guidance to local authorities as to how they should, or the considerations they should take into account before contemplating seeking an injunction of such a nature, a wide injunction which would prevent Gypsies and travellers from camping in their area. And indeed, Lord Justice Coulson, giving judgment, spoke in terms of a feeding frenzy. You'll see that on the PowerPoint. He said it would be unrealistic to think that their widespread use, that is, of wide injunctions, has not led to something of a feeding frenzy in this contentious area of local authority responsibility. And then he said this: first, these injunctions have had the effect of forcing the Gypsy and traveller community out of those boroughs which have obtained injunctions, thereby imposing a greater strain on the resources of those boroughs and councils which have not yet applied for such an order. Secondly, they've created an understandable concern amongst those authorities who have not yet obtained such injunctions to seek them forthwith. And so the knock-on effect has been quite stark. And the problem then for Gypsies and travellers, as more and more local authorities sought wide injunctions, which was that they were effectively being driven out of areas. And indeed, one could see driven far and wide in order to avoid the possibility of being committed for contempt of court in breach of the injunctions. And Lord Justice Coulson, in giving guidance, said this at the end of his judgment. Finally, he said, it must be recognised that the cases referred to above make plain that the Gypsy and travelling community have an enshrined freedom not to stay in one place, but to move from one place to another, an injunction which prevents them from stopping at all in a defined part of the UK comprises a potential breach of both the Convention and the Equality Act, and in future should only be sought when, having taken all the steps noted above, a local authority reaches the considered view that there is no other solution to the particular problems that have arisen or are imminently likely to arise. And as a consequence, the courts have now become much more careful when granting wide injunctions, if at all, and have also begun reviewing those injunctions which are still in place, which were granted outside of the Bromley proceedings. And there is a case that is progressing to a final hearing before, I think it's Mr. Justice Nicklin, which is likely to involve as many as 30 or 40 local authorities who will all be required, it seems, to explain to the judge the basis on which their injunction should continue. And that is likely to come before Mr. Justice Nicklin in the early new year. So again, watch this space. Thank you.
Great, thanks so much. So I think we will probably move now to questions because as I understand it, there are a couple of them in the chat. David, I'm not sure if you're able to assist us with that.
Yes, I can. First of all, I'm going to ask you a question myself, and that is the subtitle to this talk was, does the ECHR protect vulnerable minorities? Well, now, I'd like you to sum up as briefly as you can what the answer to that question is.
Well, I think I would say when it wants to, or rather when those people who are responsible for enforcing it want to. The rights are capable of being everything and being almost nothing in a way, depending on how they are interpreted and how they are enforced. And I think we've seen in the seminar that the range of protections which arise from them, depending on the facts and on the tribunal and on a host of different circumstances. So I think the answer to that is probably an unsatisfactory one, but it's potentially and sometimes, but not always.
Thanks.
Anything to add to that, Marc?
Well, just to say this, we've had some stunning victories in the courts, both in this country and in Strasbourg, relying on convention rights. And I say we, I mean the legal profession. And that includes organisations, NGOs, and the European Roma Rights Centre that I mentioned before, who've taken a number of cases to Strasbourg. But the problem is that those victories are often somewhat hollow, given that there's little implementation and little political will to address the violations that have been identified in court. So the victories can be great on the day, but ultimately Gypsies, Roma and travellers get very frustrated when they realise that little is changing on the ground. So it's difficult enough getting the cases to court. There are barriers to Gypsies and Roma and travellers in doing so, not least literacy difficulties, advice deserts, lack of funding. But then getting the case to the court, getting through the process, succeeding before a judge or the judges in the Strasbourg court is all well and good. But if nothing happens as a consequence, then that tends to undermine the trust and belief of those who we represent that litigation will do any good.
Okay, well, we've got about 4 questions, and one of them is a one-line answer, and it is, what is the name of the upcoming injunction case Marc just mentioned involving a large number of local authorities?
Shall I just indicate? I'm not sure of the name right now. I think the problem is that it would probably depend on which local authority is chosen to be the lead local authority. For example, it might be the London Borough of X and others. What I can say is that there is an intention on the part of a number of NGOs that represent gypsies and travellers to intervene in that case too. And we'll know more in December, because I think there's a case management hearing before Mr. Justice Nicklin in December. And I'm sure it gets some.
Would you mind the questioner sending you a message asking that question so that you can reply to her direct?
That would be perfect, yeah.
Yes,
that would
okay, so if you send your question to Marc, I think you'll find his email on the Garden Court website, or you can email for his attention info@gclaw.co.uk. And somebody has just flashed up that they think it's Enfield is the lead local authority. But yeah, that's as far as we can go. There are a couple of questions which are related. I'm going to summarize the questions now, and they are gypsies and travellers classed as BAME, i.e. non-white, and are Roma included in the Race Relations Act, or would they be included as a matter of common sense? So over to one or other of you for that.
Well, Romani Gypsies are a separate ethnic group and recognised as such under the Equalities Act 2010, indeed have been recognised as a separate ethnic group since the case of CRE, Commission for Racial Equality against Dutton, back in, I think, the 1982 Court of Appeal case. And they certainly fall under the category BME or BAME because of their minority ethnic status. So, yeah, that's the answer to that first question. The second question about Roma, yes, they too would be considered to be a separate ethnic group, albeit that Roma and Romani Gypsies all hail from the area in northern India where migration began about 1,000 years ago of the Romani people. And it's the Romani people that, leaving northern India, travelled towards Europe through Turkey, Armenia, and Persia, and ended up in Eastern Europe, and then some ventured further afield, and eventually, as I said, got to these shores in the late 1400s, early 1500s, at the time of Henry VIII.
Okay, the next question is about Article 10, the right to freedom of expression. And the questioner says that you, Marc, reminded us of the significance of anti-Gypsy and Roma and traveller propaganda historically, and then summarising down to the question, do the panellists see this article as having any relevance here? More particularly, has any European Court of Human Rights jurisprudence addressed whether Article 10 protects against harmful expression against Gypsy, Roma and travelling people?
I can't think of a case where the Strasbourg court has addressed that issue. There was one case involving a Turkish claimant, Roma claimant, who was very concerned about a publication made by the government, I think it was, and it made AXU, I think the case may be, but I can't remember whether Article 10 was the primary convention right in play. Certainly Article 14, the right not to be discriminated in the enjoyment of other rights was in play, and Article 10 may too have been a part of that case. What I can say is that hate speech, and the question of whether or not one can justify what is said about Gypsies, Roma, and travellers online or elsewhere, it sooner or later will come before domestic and the European Court of Human Rights, and that's because Gypsies, Roma, and traveller are now getting to the stage where they feel there's no option but to challenge those that publish online hate speech, those that fail to moderate hate speech on public platforms, and those cases will be brought sooner rather than later. The other cases that might be brought, which would involve hate speech or the failure to properly address it, may be brought against the police in instances where perhaps it's considered that they should have prosecuted for incitement to racial hatred and have failed to do so, perhaps failing to rely on and properly follow procedure and guidelines on the prosecution of hate speech. So I can see Article 10 cases coming to the fore in the near future, and I'm sure that they will form part of a chapter in the next book.
Yes, I agree with that. I think obviously, there are laws against hate speech, and it's difficult to see that Article 10 could ever be a viable defence to that. I think the real difficulty is probably getting a proper and wider understanding of anti-Gypsy, anti-Roma, anti-traveller statements as being hate speech and as being racially motivated, because that is something which I think is still, it's certainly far more common than it should be, and I think it's still not properly understood or accepted in some areas.
Now we have a question: do the children of illegal entrants have any rights in the UK? You might say that's outside the scope of this webinar, but do you have any thoughts in relation to that?
That's a very broad question, and it's also more of an immigration law question. So I'm only going to give a very brief answer, which is that children have rights, even if they themselves do not have a fixed immigration status. And there is also one of the important points that was emphasised in the case of Zumbus that I referred to earlier, is that children are not to be blamed for any kind of misconduct of their parents, if there is any. And the best interests of the child it's not an obligation that falls away simply because the child themselves does not have any immigration status.
Just following up on that point, and it is not really an answer to the question about that was posed, but we do regularly remind the courts that the children of parents who've breached planning control, perhaps developing sites without planning permission, will be affected and will be detrimentally affected if if planning permission is ultimately refused, or the family are evicted from land, because they will be thrown out onto the roadside together with their parents, and that in itself will interfere with and affect and be contrary to their best interests, and that the children should not be punished for the, as it were, the crimes or the actions, more appropriately, of their parents.
Right. Thank you for giving that a go, folks. I can say to the questioner, if you go to the Garden Court website and send that question to an immigration law practitioner if you want to take it further, or again, send the question into info@gclaw.co.uk and mark it for the attention of an immigration law practitioner. Then we've another question. Do you think the courts will gradually ignore these rights after Brexit? Presumably because we'll have left Europe for good by then. Do you want to take that?
Well, I'll just say this very briefly. We'll have left the European Union, but we won't have left the Council of Europe. And it's the Council of Europe's convention, the European Convention of Human Rights, that we're talking about. And we're still very much a part of the Council of Europe, and as a consequence, very much a state that should abide by the convention and the rights that it protects. So there ought not to be any watering down or reduced weight attached to convention rights simply because we've left the institution, the EU institution and its bodies.
Yeah, and I would just add to that that the Human Rights Act is, of course, a domestic statute which should not be affected by Brexit.
There's just some more information from the questioner who gave us the information about the London Borough of Enfield. I think there's details given on a link that he's put in. In fact, I see that one of them is the London Gypsies and Travellers.org.uk/news, and possible end to wide injunction. So if one goes to their website, presumably one find some more information there. I think we've come to the end of the questions that have been put in. Now, let's say if there are any further questions that people have, or that we've not answered just now, though they've been put, then again, you can send them to Tessa and Marc, either direct or at the info.gclaw.co.uk general messaging service, and I'm sure they'll be pleased to respond to them. So I think the time has come when I should close the questions. Now we're just on 5:30. I see that the front cover of Gypsy and Traveller Law is up on the screen, so that you don't forget about its existence. And that brings me to the poem that I referred to at the beginning of this webinar. So there's a little history here. There's a garden court tradition that on some significant occasion, a member of Chambers be designated as the bard or poet, and to produce a poem which fits in with the occasion. And the first bard was Nick Blake, now Sir Nicholas Blake QC, retired High Court judge. And when he left, the mantle fell on me. And it's not out of kilter with the topic of this afternoon. First of all, there's the convention. And then, as we've learned earlier, poetry, folk song and storytelling is part of the Gypsy tradition. And Ely Frankham was an example of that. Now, usually what I do is that I find a poem by some established poet and I do an adaptation or pastiche of it for presentation. Now, we know that the ECHR grew out of the series of treaties that followed World War II. Now, I would like to tell you that a international treaty as a subject of a poem does not happen very often. In fact, the poems that I have been able to find of that kind can be represented by one circle. However, I'm glad to say that I found part of a poem by Wilfred Owen, the First World War poet, which partly fitted into the subject of this evening. And so, with apologies to him and also to William Wordsworth, here is the ECHR, the beginning and the present. It seemed that out of darkness we escaped, through granite which titanic wars had groined, and came upon a place where nations met, and determined that they by law be joined. The basis of this law is reason, and this continent depends upon that law, as on the best of friends, which, in a world where men are tempted still to evil, stands guard against worse ill. Can there be those who would prefer to see torture or inhumanity, servitude or slavery, no right to liberty, no fair trial, nor right to respect for home, private life or family, no freedom of thought, religion, speech, or assembly? I fear that there may well be, and that they are not absent, even in our government. So we must all then vigilant be to preserve these rights for all humanity. End of poem. Over to Marc.
Thank you, David. That was a fantastic mashup of Wilfred Owen and William Wordsworth, if ever I heard one. And
David Watkinson as well.
David Watkinson thrown in too. And what I wanted to say on behalf of Tessa and indeed all my colleagues at Garden Court Chambers that it's been a real pleasure to have been a colleague of yours. You have been a fantastic advocate for gypsies and travellers and all those others that you've represented over your 40-year career at the bar. And that's just 40 years on your shoulders, not shared between a number of advocates. And involved in cases like Atkinson, Porter number 1, Cadona, which got a mention, the Olympic site, a compulsory purchase inquiry, and others, many others, and many gypsies and travellers have a lot to thank you for, David, and we too, as your colleagues do, because we owe you a debt of gratitude really for blazing a trail or clearing a path for us to follow down, and it's been a real honour and privilege. So thank you so much for chairing. Thank you and keeping us to a reasonable time, and for a fantastic poem. And I'm just going to turn over to Tessa in case she has anything to add. But thank you.
I want to wholeheartedly agree with that. I feel like you've all been shortchanged because you've heard from me instead of David, who has so much of interest to say on the subject and has done just so much absolutely fantastic work. So myself anyway, standing on the shoulders of giants really in this field in terms of what's been achieved by David and Marc and everyone else. And obviously, not least, the tradition of poetry, which is such a wonderful part of all of Chambers events. And particularly on this occasion, a very fitting way to end, I think. Thank you, David.
Well, I'm moved by that. Really, thank you very much, Tessa and Marc. And thank you for your presentations. Very thorough, very clear. And I'm sure they'll be referred back to for many months, if not years to come, as the struggle continues to maintain these rights for, as I said, all humanity, as well as gypsies, travellers and Roma community members. Thank you very much. And thank you to you all for coming in to listen and participate in this webinar. We hope you've enjoyed it. We hope you've found something to learn from it. And we hope to see you again at other Garden Court seminars. Thank you very much, and good evening. And I hope you find something to enjoy in it in these times. Farewell.
Thank you. Bye-bye.